So hello, everybody, if you can hear me. Thanks for joining us. Thanks for joining the First Amendment Museum for Press Freedom and Social Media with Emily Hockett. This is part of our online speaker series here at the First Amendment Museum. If this is your first time joining us, we're a nonpartisan nonprofit located in beautiful, sunny, especially today, Augusta, Maine. I'm Max Nospish, the Manager of Education and Visitor Experiences here at the museum. We rely on gifts from viewers like you all to continue the work we do. So if you want us to continue more and have more events like this, please donate to us. I'll put the donation link in the chat, of course. And tonight we are joined by Emily Hockett, who is the Reporters Committee's Technology and Press Freedom Project Fellow. Did I get that right? That was a bit of a mouthful.
Yes.
I did, yes. The Reporter Committee's Technology and Press Freedom Project Fellow. Emily is a graduate of the University of Virginia School of Law, where she was a member of the First Amendment Clinic, so the perfect person to be talking. She's worked on public record matters and amicus briefs under the supervision of Reporters Committee's attorneys. Emily received her BA from New York University. Emily, thanks for joining us, and I'll hand it over to you.
Thank you so much for having me, Max, and thanks for putting this together. I'm going to talk to you all tonight about press freedom and social media, and in particular about the Reporters Committee's work pushing back against state laws that regulate content moderation on social media, one in Florida and one in Texas. So I'm going to begin by just giving a quick overview of the law that governs social media, where it comes from and why it matters to press freedom. And then I'll give a bit of detail on these two laws that I mentioned in Florida and Texas. And after that, I'm hoping to leave ample time for questions and discussion in whatever format you all typically use. Max, I'll defer to you on that front. So first, we have to start with the First Amendment, of course. The First Amendment relates only to attempts by the government to censor or regulate speech, not private entities. And it requires demanding scrutiny of government censorship that's based on viewpoint and a slightly less demanding standard for government restrictions of commercial speech, so advertising, that kind of thing. And the Supreme Court has also delineated a set of categories that it deems wholly unprotected by the First Amendment. So those categories are child pornography, obscenity, incitement, and defamation. But those categories have been quite narrowly defined by the Supreme Court, and it has said that that is an exhaustive list of categories that are unprotected. And so in conversations about problematic social media takedowns and deplatforming, so for instance, President Trump getting kicked off Twitter, the First Amendment often gets invoked, but as I said, the First Amendment doesn't obligate private companies to give a platform to or host certain speakers, even when those speakers happen to be president. So just as you're not required to host people who are saying things you don't like in your own backyard, social media companies aren't required to either. This doesn't mean, though, that the First Amendment has nothing to say about social media or speech on social media. I wanted to discuss a little bit about the First Amendment protections for editorial decision-making, which is a form of First Amendment protected speech that when regulated by the government must undergo First Amendment scrutiny. So the origins of protection for editorial discretion come from a case called Miami Herald versus Tornillo, which created a right of reply statute, or challenged a right of reply statute. And this all came about starting in 1972 with Pat Tornillo, who was a leader of a teachers union in South Florida and a candidate for the Florida House of Representatives. He found out that the Miami Herald had criticized his candidacy and endorsed his opponent. And so he wrote a reply to the newspaper and accused it of defaming him and demanded that the newspaper print his reply. And he argued with a strong basis that it was legally obligated to do so under a right of reply statute that Florida had at the time, which provided that if a candidate's character or official record was called into question or criticized by a newspaper, that candidate had a right to demand that the newspaper print free of charge to the candidate a reply. And so the Miami Herald refused to print Mr. Tornillo's reply. He filed a lawsuit against them, and that lawsuit ended up before the United States Supreme Court, which struck down the right of reply statute as violating the First Amendment, because the Supreme Court held newspapers have a First Amendment right of editorial discretion, which allows them to decide what appears on their pages, and they don't have to give certain speakers a platform if they don't want to. So the fact that this protection for editorial discretion begins with a case about newspapers is particularly interesting and notable, and speaks to why the Reporters Committee has weighed in on these cases, even though news organizations and journalists aren't parties to cases challenging these laws in Florida and Texas that I'll get into later. And the Supreme Court has itself, since Miami Herald versus Tornillo, applied this protection for editorial discretion and decision-making in a wide range of contexts beyond press cases. So, for instance, it's held that a parade organizer has a First Amendment right to choose the groups that are allowed in a parade, even when it's making viewpoint discriminatory decisions. This is a case called Hurley, involving a St. Patrick's Day parade, where the parade organizer refused to allow a LGBTQ group to participate. And this quote on the slide sort of sums up the principle of the protection for editorial discretion. So I'll let you read that. And so another key social media law is Section 230 of the Communications Decency Act. And this is a federal law that says that websites and online services are not liable for third-party content. And immunity under Section 230, unlike some other laws, doesn't depend on the state of mind of the website. It doesn't matter how aggressively the service moderates content. It gets that liability shield pretty much regardless. And Section 230 was enacted by Congress in the early days of the internet. And it was designed with sort of two goals. First, with promoting free and open discourse online. And second, to encourage the hosts of third-party content to engage in some amount of content moderation. And it achieved those goals through this liability shield to temper the incentive that online platforms would otherwise have to remove valuable speech because they feared liability. And this is particularly relevant in the context of journalism that might be perceived as controversial, because internet companies or internet platforms might choose not to host that journalism if it seemed particularly controversial, because they would be worried about liability. And there's sort of three reasons in my mind why Section 230 matters to journalists. First, I think without Section 230, it's really hard to envision an internet that would allow contemporaneous access to breaking news, particularly on things like public health emergencies, terrorism, sort of evolving stories that are controversial and of really high public interest. And second, journalists rely themselves on an internet that allows them to post and amplify their own reporting. So journalists have strong presence on Twitter, where they're often posting stories they write and interacting with readers. And then third, journalists use online platforms to identify sources and stories and communicate directly with readers online. But as I'm sure many of you know, Section 230 has its critics. So for instance, former President Trump has been a vocal critic of Section 230. And he says in this tweet on the slide that without it, Twitter wouldn't exist for long. And I think that's probably right, at least in its current form. I think without protecting against liability for the content that it hosts, social media companies like Twitter wouldn't be able to exist. And it's true that I guess it's possible that it's true that Twitter isn't about free speech, because Twitter has historically argued that, it wants to promote free speech and open dialogue on its platform, but it still has the First Amendment right to curate content on its platform how it sees fit. So it can be about free speech if it wants to, but it doesn't have to be under the First Amendment. And then this second piece in the second part of the tweet here expresses a sentiment that is shared by others, that mainstream social media companies were silencing conservative voices and were against conservatives. So that sentiment was shared by politicians other than President Trump, and ended up motivating the laws in two states, Florida and Texas, that regulate how social media companies display and moderate content. So I'm going to talk to you a little bit about these laws now. So Florida and Texas both enacted laws that regulate content moderation in a way that they do so differently, but are both framed as a sort of must-carry mandate. So the Texas law says that platforms can't censor users on the basis of the viewpoint that the user expresses. And the Florida law says that platforms can't willfully deplatform Florida politicians by suspending or barring them from a platform. So as you can tell, the Texas law is broader, and it might force content and platform to host content that's dedicated to Holocaust remembrance to also host Holocaust deniers, for example, because otherwise it would be arguably discriminating based on viewpoint. But legally speaking, these two laws pose the same constitutional concerns. These laws also have disclosure mandates and due process provisions. So they require the disclosure of terms of service and an explanation to users about why their post was removed. So this will come up later when I go into the legal challenges to these laws. And as I mentioned earlier, the motivation behind these laws seems pretty expressly to come from a belief that social media companies are silencing conservative voices in particular. But in the legislative findings for both of these laws, they say that they were motivated by a sense that platforms have too much market power in the current economy, and that intervention of some sort was needed in order to promote free and fair discourse online. And this is sort of an aside, but initially the Florida bill had a provision, or the Florida law had a provision excluding companies that own and operate a theme park or entertainment complex. And this very clearly referred to Disney. And this part of the law, and it referred literally only to Disney. That was the only entity to which this clause applied. And so this part of the law received a lot of criticism and attention. Then later, once the law had already been passed, Governor DeSantis pushed for the loophole to be closed, seemingly not in response to the criticism, but because Disney came out against a different Florida law that bans the teaching of gender identity and sexual orientation up to 3rd grade. So, as you can probably imagine, both of these laws were challenged in court. And they were challenged by two trade associations that represent the interests of tech companies. And the theory behind this case is that these laws infringe on the editorial discretion of the platforms that the Supreme Court said was protected in Miami Herald versus Tornillo. So the platforms say that they're making expressive choices when they decide which pieces of content to distribute to their audience and how to distribute that content, and that the First Amendment protects those choices. And a state's effort to override those editorial choices in order to rebalance the discussion on platforms is illegitimate because it is doing the exact same thing that the Supreme Court said the state of Florida couldn't do with its right of reply statute in Tornillo. So the platforms also argue that these laws are preempted by Section 230. So in other words, they're saying that because Congress enacted a law saying internet companies are shielded from liability for third-party content, states can't enact laws that impose liability on platforms based on the way that they choose to host that content, since doing so would contradict the federal law, something that state laws are not allowed to do under the Supremacy Clause of the US Constitution. So the outcome of these legal challenges. So both the Florida and Texas laws were initially enjoined by federal district courts, which concluded that each of them violated the First Amendment on several bases. And this basically means that the court stopped the statutes from taking effect temporarily. And so in Texas, the injunction was then stayed, meaning basically reversed. So the law was able to go forward or take effect by the Fifth Circuit. But then the Supreme Court stepped in and vacated the stay of that injunction, basically meaning that the original ruling by the district court enjoining the law stood. And the injunction was vacated without explanation by the majority. And it was a 5-4 decision with Kagan, Alito, Thomas, and Gorsuch in dissent. And Kagan didn't give an explanation as to why she was dissenting, but Alito, Thomas, and Gorsuch all joined a dissenting opinion written by Justice Alito explaining that these were issues that the court needed to address. Basically the issue of the constitutionality of laws regulating content moderation. So those were the rulings before the merits stage in the litigation around a preliminary injunction. The Fifth Circuit, when it reached the merits, upheld the statute in a 90-page opinion, and it rejected the trade association's arguments that content moderation is a form of editorial discretion. And the trade association has since filed a petition to the Supreme Court asking it to weigh in and asking it to reverse the decision of the Fifth Circuit, which is the federal court of appeals in Texas and in other states around that area. And in Florida, the 11th Circuit, which is the Court of Appeals in that area, largely agreed with the trade association's arguments, at least on the Tornillo editorial discretion issues. It said that the statute violated the First Amendment, but it did uphold the disclosure provisions, so the provisions requiring that platforms make public their terms of service, that kind of thing. And both Florida and NetChoice, which is the trade association, have filed petitions with the Supreme Court also. So this is almost surely going to end up before the Supreme Court next term. The Supreme Court has conferenced on the petitions in these cases already twice, and it has sought the views of the United States Solicitor General, which is the representative of the executive branch of the federal government before the US Supreme Court. And currently, both laws haven't taken effect. They're both stayed pending the Supreme Court's decision on whether or not to review them, which it should make probably early next term. And just in general, the Supreme Court typically weighs in on cases where two federal circuits are split and where there's a contentious issue. So this sort of fits all of the categories of the kind of case that the Supreme Court will likely grant cert on and hear. And so in terms of why the Reporters Committee thinks that these laws about content moderation and about these tech companies are relevant to our issues and our equities, we've filed briefs in the district court, the Court of Appeals, and I think have probably filed 5 or 6 briefs in these cases in total, and I'm sure we'll file more if the Supreme Court agrees to hear them. but we're involved in these cases because we think that this is about more than just big tech. And there's a reason that lawmakers in Texas and Florida are the same lawmakers that are pushing for these bills are pushing for reforms to New York Times versus Sullivan, or laws revisiting New York Times versus Sullivan to make it easier to sue journalists for defamation. And these laws sort of represent this concerning trend that we see by elected officials cracking down on people that they see as their ideological opponents, who've grown, I guess, in their words, sort of too powerful in the marketplace of ideas. And neither Texas nor Florida has really offered any sort of limiting principle that would insulate the press. So to us, it's very important that the Tornillo rule not be misconstrued as a protection for newspapers, sort of as a favored class of publishers, and instead the case is really about editorial function, whether government has seized control of an aspect of the speech process, sort of in this case, deciding what to publish. And in our view, reading Tornillo as narrowly focused on the kinds of editorial judgments that newspapers in particular make would be sort of analogous to the kind of licensing schemes in Old England that the First Amendment was expressly intended to avoid, giving the government power to determine sort of favored or legitimate speakers is clearly not the intention behind the First Amendment, nor is it consistent with the rationale that the Supreme Court gave for its decision in Miami Herald versus Tornillo. So I'll pause there and see if folks have questions about these two cases.
Yeah, so I have a question. Any official predictions or prognostications on how the Supreme Court is going to rule in these cases? If you had to bet, what do you think?
Yeah, it's very, very hard to say. I think it's almost certain, as I said, that they'll take these cases. I think the easiest path and the sort of least controversial path is to say that these laws are both preempted by Section 230, and that the federal government has already legislated in this area, and so state laws can't contradict or attempt to sort of occupy the field that the federal government has already spoken on in Section 230. And there's a principle in constitutional law called the canon of constitutional avoidance, which says that courts shouldn't reach constitutional issues if they don't have to. So under that principle, the Supreme Court would, in theory, begin its analysis with a statutory issue, and if that statutory issue could resolve the case without reaching the constitutional issue, then the court is obligated to do so to avoid sort of unnecessarily weighing in on the meaning of the Constitution in cases where it's not sort of expressly warranted. So that's probably the easiest path. The Supreme Court this term is hearing a case, its first case ever, interpreting Section 230. So the fate of that preemption argument will possibly depend on how the Supreme Court decides the Section 230 case before it now. And that case is Google versus Gonzalez, which is a case that we've actually also filed an amicus brief in. These are cases that were brought by family members of Americans who were killed in terrorist attacks abroad, and they're suing social media companies for algorithms that recommend content to people who then go on in their argument to commit acts of terrorism. So in the case of Google, they're charging that YouTube's auto recommend feature led individuals to view ISIS videos, and then those individuals committed acts of terrorism. So they're arguing that those recommendations should be that Google should be liable for those recommendations. Google owns YouTube, so that's why they're the defendant.
And so the Reporters Press Committee have you guys filed an amicus brief in that case as well?
So yes, so we have, and the issue there is whether Section 230 applies to recommendations. Or whether it applies to what they call traditional or editorial functions. And our brief argues that the line that the petitioners argue should exist between recommendations and traditional editorial functions is untenable, and that drawing that line in the context of the internet and social media is impossible because anything that pops up on your feed is curated by an algorithm that is, in a sense, recommending you content. So anything that exists on the internet, the same is true with, newspaper websites. Anything that says sort of, you might like, et cetera, could be considered a recommendation. And to create such a large loophole in Section 230 for those kinds of recommendations would be incredibly problematic and undermine Congress's intention when it enacted the law. But if the Supreme Court disagrees with that, then it's possible that it would take such a narrow view of Section 230 that it would find that it did not preempt these Texas and Florida laws. And if it took that approach, then it would have to reach the constitutional issue. Sorry, that was a very long answer to your question.
No, it's fine. So the Reporters Committee, do you guys see, and I'm having you speak for the entire Reporters Committee, maybe speak for yourself or whatever you feel comfortable with. Do you guys see a largely unregulated, unfettered internet the best way forward for freedom of the press online? Without the less regulations from government in terms of big tech, social media companies, do you think that is the best approach going forward into the future? Does that question make sense?
Totally. Okay. Well, I won't speak on behalf of the Reporters Committee for this one, but I think it really does depend on the proposal. And I think there's a lot of proposals that are attempting to reform the way that the internet works and create liability for internet companies that are tremendously concerning in terms of the implications that they have for press freedom and just for sort of free speech values generally. And so I haven't seen a proposal to amend Section 230 or to regulate the way that content gets moderated on the internet, sort of more generally, that hasn't raised significant both normative and constitutional problems. But I wouldn't rule out the possibility that one exists, and maybe someone who's more thoughtful than I am and smarter than me will come up with one, and I will be eating my words.
Well, so I don't know if you've heard of this case, but this is one I bring up a lot to all sorts of people to sort of demonstrate the moral gray areas we get into with the First Amendment, or maybe the hard pills to swallow. Have you heard of a case called Packingham v. North Carolina?
Vaguely, but say more.
So North Carolina banned sex offenders from, or attempted to ban sex offenders from registering on social media platforms. And whenever I ask anybody, does that sound like a good law to you? Everyone's like, of course, that sounds like a great law. And it was overturned on First Amendment grounds. And then people go, what? How? Why? Like, so do you find yourself having to sort of think about these hard pills to swallow and these sort of moral quandaries, or these these things that may seem good on the surface, such as banning sex offenders from social media, but have larger implications that may be not so good? Do you find yourself dealing with these sort of moral questions, these philosophical quandaries yourself and in your role with the Reporters Committee?
Totally. Yeah. And I think it's, maybe personally, like sort of more fraught, but I think in terms of my role at the Reporters Committee, I think having our framework is always sort of how does this law or how does this proposal or how does this case implicate the freedom of the press and the rights of journalists more generally. And so because we're always going back to that question, the answers become clearer, and we also have this constituency that we can talk to and ask questions of, and sort of solicit feedback and say, how would this proposal impact your equities, and think about sort of the broader implications of a given law for journalists. And I think just having that framework makes the both legal and normative questions here less fraught and just a little bit clearer and less abstract too, because you're really looking at, how would this impact journalists, their reporting, their ability to get their message across. And I think that always elucidates the problems with a proposal that might seem on its face to be really beneficial or helpful. Because when you see, how would this impact journalists? How would this impact the distribution of information online? Often it can be incredibly harmful and in a consequential way, make it harder for journalists to do their jobs. And so sort of going back to that framework and thinking about the relationship between a given proposal and the free press, I think always makes it easier to answer those hard questions.
So how do you guys define what is the press or who is a journalist, especially online, right? Is it just anybody who writes a Facebook post about the news, or do you have some sort of standard of this is the press, this is journalism, this is not? How do you guys sort of define that, I guess?
Yeah, I mean, I think we try not to be in the business of saying, you're a journalist and you're not. I think it's much more about the function that someone's performing. So if they're acting as a journalist or a citizen journalist, even if that's, mostly posting on Facebook, if they're performing the functions that we traditionally consider journalism, then it's more about sort of the protections that they receive. And in the legal context, there's a sense that the Supreme Court has articulated that that in some ways journalists have special status under the First Amendment, but often the journalists are not treated differently under the law in some circumstances. In some circumstances they are, but in a lot of circumstances they're not, than just your average member.
What are some of those circumstances, just to clarify? In what circumstances do journalists get special protection or status under the First Amendment? And what are those?
So not under the First Amendment, but under some state shield laws, for example. So almost all states have some form of reporter shield law that limits when a reporter has to give information to a government or to a court about that they've gathered as a part of their journalism. So, for example, if a journalist is subpoenaed by a court for her notes at a protest to identify someone who was brutally arrested by a police officer, for example, a journalist would be able to often invoke a reporter's shield law to say, please ask someone else, basically, don't ask me for my notes because I'm a journalist. That would sort of threaten my ability to perform my function freely. And so, in contexts like that, that's a really easy case where, if there's another source of information that court could go to and get the same thing that the journalist wrote down, then they should do that. And under most state laws, they have to do that. So that's an example, but other examples, like when a court can kick journalists out of proceeding, there's typically not under the First Amendment special access rights to courts for journalists. It's usually the right of the public has a right to attend court proceedings. The public has a right to access judicial documents. That right is most salient for journalists because journalists are performing the public oversight function and are most actively attending court proceedings, doing things like that.
So do you ever worry about, people that are performing the functions of a journalist, say they have a podcast or they have a blog, maybe a YouTube channel, whatever, and but they're spreading misinformation or disinformation. In your opinion, do you think the state has a sort of right or obligation to crack down on those people? Or do you think that even that going there is already like too far gone in terms of a First Amendment violation?
So say what you mean more. So what would
Say I have a podcast and I'm
yeah,
spreading misinformation,
yeah,
disinformation. Say I'm lying about, maybe I'm not even intentionally lying, but I'm just getting the facts wrong about maybe a law here in Maine, and maybe Maine passes. Would it be okay? I guess, or what do you think about the idea of a a legislative body or a state or a federal government passing a law that says, Max, you can't say that. You're spreading too much misinformation, disinformation online with your YouTube channel or your podcast or your Facebook posts. I say this more as like devil's advocate, because I hear people bring this up a lot, that this is a policy that they would like to see enacted. So I would love to hear you either great idea or take it down with alacrity and ease. Up to you.
Yeah. Well, I mean, that such a policy would definitely be unconstitutional. But I think the key thing, at least sort of for me, is like, it shouldn't be the government that's forcing certain speech to be taken down or kept up. That isn't the role of the government in a society that values free expression. That private companies, let's say like Twitter or Facebook, can make determinations about how they want to treat disinformation, and individuals can through counter speech argue that something is disinformation, and that's an effective way of responding. And there are all kinds of mechanisms other than government regulation that you can address the sort of social problem of misinformation, but that there are many more problems that come up when a government attempts to regulate the kind of speech that's allowed than are solved. And instead of using the government as a mechanism to solve these social problems, that other entities can sort of fill in that role.
But doesn't that sort of scare you, like the idea of again, these big tech companies that have such a large share of our discourse, Facebook, Twitter, Instagram, TikTok, Snapchat, you name it, that these sort of large companies owned and operated by a very select few people have so much control over what is and isn't allowed on their platforms? Doesn't that sort of, I think when people go, oh, this is, Donald Trump got kicked off Twitter, what a violation of the First Amendment. Yeah, that's not legal, but maybe sometimes they mean the spirit of free speech, or the cultural aura that the First Amendment has with free speech, that it's violating some more, I don't know, spiritual thing we're striving for in the United States of unfettered free speech. So does it not worry you that these big companies can often be just as, engaged in just as much censorship, or maybe even worse than the government?
For sure. Yeah. No, and I think that's sort of a separate social problem, that like we are, the way that the internet is structured now is that a very small number of large companies have a very outsized role in determining what information people receive, how they receive it, and their business model is based on making people spend as much time on as extreme on their platforms as possible, which results in them feeding people sort of extreme and outrageous content that may or may not be true. And I think that is a really big social problem, and one that I don't think laws regulating what people say online solves at all. I think you could look to antitrust law, for example, as a form of intervention. There are, of course, many problems with that. Yeah, no, I think that it's a really big problem that these big companies have such an outsized role in our political and sort of social discourse.
And so does it always, at the end of the day with these topics, does it always go back to Section 230? Is that the cloud hanging over all of our heads? Because, and you know, Section 230 was written in the 1990s, right? Like that's when it was implemented. So is that an argument that it's time to revisit this law? It's time to change it, get rid of it, whatever? Or is Section 230 good? And the naysayers, they just need to get with it and learn and you know, so what are our opinions on Section 230, this cloud overhanging all of these conversations?
Yeah. I mean, I think as I was saying earlier, it's like I haven't heard a solution to this problem that's better than the status quo. The status quo being Section 230 as a relatively expansive liability shield. I think all of the proposals that I have heard to amend Section 230 or replace it with something else create more problems than they solve, and pose tremendous threat to free speech online and to press freedom. That said, again, it's possible that there are things that I'm not thinking of, and I think there are a lot of people doing some really smart thinking on this. But I think that there's a tremendous value that I think is often hard to see in the status quo and the internet that the status quo has created. And I think like there are obviously a lot of problems with these large companies, and there are a lot of social problems that are created by social media, but there are also a lot of benefits from having internet that allows people to freely exchange ideas and converse with one another. And I think it's easy sometimes to underestimate the value of the status quo and overestimate the extent of the harm. And I think there's also just this class of people that are employed, probably myself included, to attempt to come up with new ideas to solve these problems. And I think sometimes those people come up with ideas that are just would create more problems than they would solve, and would upset the status quo in a negative way.
So I see Jim Campbell, audience member, has turned on his camera and has his hand up. Jim, I'll let you, you have something you want to say, with the caveat is I'll be moderating. So say your piece.
Yeah, I was just typing a note in the chat too, but I think it's important to remember when thinking about 230 and what does it mean now, and is it the same thing? The people that wrote that act and championed it and passed it are still alive and have been asked. One of them still in Congress, actually. You know, if the world is so different now that the intent of the act, you know, needs to be modified. And as far as I know, they have all said, no, this is exactly what it was about. And so I think that a lot of the conversation about, well, that was fine in 1996, but it's not fine anymore. That's fine. You can have that opinion. And but then to say that it's not relevant anymore, I think that is a big leap. And based upon the concerns of the senator who is still in the Senate these days, I don't think that there is a divergence from the intent when it was passed by Congress, with a substantial support, by the way. It wasn't a 2-vote majority in those days. I think that it makes good sense to take that into account, which I think a lot of people who have been expressing their opinions on the subject have not taken into account.
No, I totally agree with that. Yeah.
Thank you, Jim. And so I want to take the conversation there. So we talked about Texas and Florida, and it seems like a lot of the states that have a huge, or maybe not a huge, but are attempting to, I don't know what the term is, crack down or regulate social media or big tech, are more conservative, Republican controlled states, Texas, Florida. Why is that? And are we seeing similar efforts in left-wing state or Democrat controlled states, liberal controlled states, however you want to call it? Are we seeing any efforts from the other side, or is this a uniquely conservative Republican phenomena?
Yeah, I mean, I think both of these laws followed President Trump getting kicked off Twitter and other social media platforms. I think that was if you were to point to one catalytic event, that was probably it for both of these laws. And I think there's just generally been a lot more discourse about conservative or anti-conservative bias on social media on the right. But I think it's also really important, just in terms of, our equities at the Reporters Committee, to put these proposals in the broader context of the legislative agendas in both of these states, in Florida and Texas, because both Florida and Texas are right now considering proposals to change and expand liability for journalists for defamation. And so in Florida, the proposal is significantly more expansive and very, very directly contradicts the Supreme Court's precedent in New York Times versus Sullivan, which provides strong protections for journalists against defamation actions. And then this Texas proposal is much more narrow, but makes it annoying for defendants in defamation actions who are filing anti-SLAPP motions to dismiss, so motions to have meritless defamation action against them dismissed expeditiously because it lacks merit. So the fact that both of these proposals are coming up in the same states that have these social media laws, I think makes clear that there is a sort of animosity towards the press that motivates sort of these proposals that may seem on their face not to be that similar, but share those characteristics and are troubling for that reason.
Yeah, and I'm sorry, do you have more slides? I didn't know. I thought that was the end of the presentation. I'm so sorry if you did.
Oh, no. I mean, I'm happy to share more slides.
No, please go through the slides. Sorry, I thought that was the end of the presentation.
Oh, no, I don't have more on this presentation, but I did just do a presentation on these Texas and Florida defamation laws. So if you want more slides, but no, I'm happy to just talk about those.
Sure. So any final questions from our audience? Anybody have anything that they want to ask Emily while we have her? Let's give it a second for people to type if anybody has anything. Okay, question for William Clardy. Thank you, William. William has attended a couple of these. I always appreciate the support, William, and you turning up. William Clardy asks, what about localized efforts to delegitimize little guy reporters using social media? And do you understand the question, or do you need more context?
I would love some more context if...
And William, if you want to turn on your camera, I mean, I know you can hop on if you want to chit chat. But if you want, you can just put it in the chat as well.
Sorry, just had to give Zoom permission.
Oh, no, okay.
Yeah, what I was really asking about is, I know there's a lot of attention on, states and attacks on the big tech, but it seems to me there's also a less noticed but more pervasive effort, frequently by local governments, to delegitimize, independent reporters or journalists who are trying to leverage social media to serve that, local newspaper, local reporter role.
Yeah.
I'm just wondering if, I know you had kind of alluded to that in a couple of spots with when someone's acting as what we traditionally view as a reporter. Have you got any insights from where the Reporters Committee or any of the other activity has, tried to weigh in on any of those issues or seen a need to weigh in?
Yeah, totally. And I think you're absolutely right that that's a really big problem. At the Reporters Committee, we've sort of seen that problem, and just generally the underfunded nature and of local journalism in general, and the threats that that anti-press sentiment have to local journalists in particular. And it's very concerning. We've established this program a couple of years ago called the Local Legal Initiative, where we have lawyers on the ground in Colorado, Oklahoma, Tennessee, and Pennsylvania, which are states that have laws that are particularly concerning for free press issues, and places where local journalists are facing sort of more obstacles than the average state. So that's sort of one intervention that we've taken to help that. I think another thing that's really concerning on that issue is like for larger media organizations, they have the resources to defend against a meritless defamation action, for example, but the entities that are being really put out of business by lawsuits that are just intended to chill speech are these smaller nonprofit newsrooms, that kind of thing. So it's really concerning, and it's really, really bad. And that's why we need, sort of across all 50 states, strong protections against meritless defamation actions, allowing for expedited dismissal of them, and strong protections for journalists in the form of press shield laws.
Okay, thanks. Thank
you.
All right, so we will finish up with this question. This is a great question too, because I've heard rumblings about this as well. This is from Jim Campbell. Thank you, Jim. Any thoughts about what the outcome of reconsideration of the Sullivan case might be if it were to wind up before this Supreme Court? So maybe just like very 2-sentence, what is the Sullivan case? Just a reminder. Yeah. And that I know Clarence Thomas has mentioned that it's time to rethink this case. So kind of that context, and then what might happen if something similar comes up before this court.
Yeah. So the Sullivan case, New York Times versus Sullivan, is I think 1965 case that established strong protections against defamation cases brought by public figures. So it established what's called the actual malice standard for statements about public figures in defamation cases. So President Trump said that he was wanting to appoint judges that would open up libel laws, and there was a decision a couple of weeks ago where a Trump appointee in Florida expressed his dissatisfaction with the status quo on Sullivan. And then Neil Gorsuch and Clarence Thomas of the Supreme Court have both said that they think that Sullivan should be revisited. I think that in terms of like what that would look like, I think we're very far away from a Supreme Court case that would squarely raise that issue, for one. And I also think that that the law on interpreting Sullivan and the fact that it's been precedent for so long weigh in favor of it being upheld and maintained. But the fact that that people are saying that it should be overturned is incredibly concerning and would be tremendously threatening to press freedom. At the Reporters Committee, we're not super worried about that yet, but its prospect is very concerning, and especially after several members of the current Supreme Court have expressed dissatisfaction with it.
All right. Well, thank you so much, Emily. This has been terrific. It's nice to sit down with a legal mind who knows the law like you do and can tell us all about it. So thank you so much. And I appreciate you taking the time.
Well, thank you all for spending your evening with me and for your really thoughtful questions. And thank you, Max, for all of your questions and for organizing this. It was really a pleasure.
Thank you. All right. Have a good night, everybody.
Bye, everyone. Good night.